And a very warm welcome. This is Viewer Exclusive on Viewer Television. Now, there's been a growing concern within the creatives, especially in Nigeria. Concerns on how to protect yourself, especially what's attainable within the law. My name is Chinonso Chekwers, and I don't know the answers, but I'll be asking an expert right after the break. Many thanks for staying with me on Viewer Exclusive. Now, like I mentioned in my introduction, it's a concern that people in the creative space, people in the creative industry are beginning to grow concerns about how to protect themselves. Like it's an industry that, you don't really get to see your profits and you're this right on time, and there's a lot of undefined things. We don't know how we can be protected in this space. But fortunately for us, there are laws that guide the people in the creative space. And my guest today is Janet Larry. She's an IP and entertainment lawyer, and she's going to be answering those questions for us. Thank you for coming on the show, Janet.
Thank you for having me.
It's such a pleasure to have you.
Yeah, thank you.
And you look like an entertainment lawyer.
I do?
Yes.
Does it look?
And she's going to ask, like, how do they look? How do we look?
That's what I'm
do we have a look? Yeah, you guys have a look. You look like... All right, thank you for coming on. Lots of questions to ask. Creatives are... Especially, we're not going to run away from the fact that it's becoming a concern since the whole Mohbad case. Nobody understands what's happening to his royalties and all of that. So moving forward for people right now in the creative industry, that is why we want to do this, so that people know how to protect themselves, how to protect their rights, and know what's attainable for them. So first of all, what I want you to do for us now is to help us to identify these creatives within this space. Who are the creatives that people like you cater to?
Well, I will say that there are three major kinds of creatives. We have the writers, we have performers, and then we have designers. Okay. Now, this may seem narrow, but it actually covers across a lot of fields. So I'll give an example for writers. We have songwriters, screenwriters, joke writers, even poets. Basically, every kind of, any form of writing, even copywriting, is all under writing. That's as a group or part of creatives. Then we have designers, people that, whether in fashion, graphic designing, basically across different fields. Then the final one is performers. Performers are the popular ones. Performers are basically people that are in front of the camera under the spotlight. So we have people like musicians, we have dancers, we have actors. And then, those are the major kinds of creatives.
So performers are usually the people who are under labels right now. Most times they're not independent, so they are the ones who actually fall mostly into the
creatives.
They who fall into the category of people who have these concerns. But we're going to come down to them. Let's talk about people who are in design now. Let me take, for instance, an architect. They're into design, but they fall under that. Are they also under creatives?
Yes, they're under creatives. And the most popular law that protects creatives in Nigeria, which is copyright law, also protects architectural design as a copyright. So yes, they're actually creatives.
They're actually creatives, because we don't see them as that, because we feel like they have a structured industry already. And
the thing with the creative industry is that it's not one. It's calling someone a creative is a description of different kinds of things. And the most important thing I'll say is that the reason why people think of the entertainment industry when they think of creatives is because the entertainment industry is about showbiz. There's a lot of marketing, there's a lot of promotion, there's a lot of glamour. But they are not actually the only creatives. People in, I'll give an example, people in agriculture, there are people that are creatives. There are people that create and innovate, invent tools. Even people that are in health tech. So basically, if you're in any form of technology, you're also a creative. Okay. And depending on what you do, you can either be protected by trademark, which is a type of intellectual property, or copyright, which is also another kind of intellectual property.
Okay, but we'll get into that. But let's try to understand all of this. Now, as a designer, say in the fashion industry, I work under a fashion label, and I have a project and I'm supposed to create stuff, and I create, say, a collection, right?
Yeah.
A collection. Is that my intellectual property, or does it belong to the fashion house in this instance?
So it
now?
depends on the agreements that you have. It could be an oral agreement, or it could most likely be written, because if it's when it's written that it can easily be honored. Most oral agreements are usually what cause the kind of rifts and scandals that we see on social media. So what I would say is it depends on the agreement that they have, but ideally the design that someone creates belongs to the person that created it. But if you enter into maybe an employment agreement with someone, their employment agreement can say that all intellectual property created during the course of the employment with the materials of your employer during work hours belong to the employer. So there are a lot of nitty-gritties, there are a lot of complexities that will determine who exactly owns what. So yeah.
But is it important to know what is what in
Yes.
this? Because we see a lot of those kind of conflicts, especially like you mentioned in social media,
Yeah.
where you see this person saying, I worked under this fashion house for so and so amount of time, so definitely this is mine. Is it important to begin to go into this kind of agreements you should tell your employer, okay, let's begin to state out what belongs to me and what belongs to the house?
Well, I think there's even a flaw in that scenario, in the sense that the person shouldn't be your employer before you make that agreement. So
Okay.
you shouldn't even be working with somebody if you do not have anything written down. It doesn't have to be a complex 20-page document. Just state somewhere. It could even be an email exchange between you guys. It's very important to state that this is what I'll be doing for you, this is what I will get in return, this is who is going to get credit for ownership. And when I leave, if I will continue to be the owner, you guys will stop production of this because it belongs to me, or you guys will continue and have a non-exclusive license to continue using it, while I can give someone else a license, or I can also reproduce somewhere. So all those details and information, unfortunately, they are not really things that a creative will be thinking about in the moment, and that's why it's important to involve a lawyer. And in this case, I think the best kind of lawyer for a creative will be an intellectual property lawyer, what we call IP.
Yeah, because I was going to just ask in my next question, if such agreements hold water, if the creative by him or herself write this agreement and asks his employer to sign.
Well, the most important thing is that the employer ended up signing.
Okay.
So whether signing,
so either way, it's a binding document.
Yes,
it's a binding.
and it doesn't even have to even be a signed contract. It should be, but it doesn't have to be an email exchange that is acknowledged by both parties and that they've started working on. So if you can prove that, okay, the relationship you guys have came out of that email exchange. So for instance, if there's responses and it's obvious that this person has agreed to the terms in that particular email exchange, then you can say that can serve as a contract. Of course, not the regular traditional contract, but that is an implied contract on its own. So it's very important to state out all these things beforehand, not after you've become an employee.
Okay.
And so, that's even just in an employment scenario.
Okay, so there are also scenarios where you as an entrepreneur, you are being innovative and stuff, and you'd have to protect your property. And that is bringing me to ask the question, let's try to understand copyright, patent, trademarks. When should we begin to look at those things as a creative, and what are they?
Okay, I think I'll start from what they are. Copyright is the popular one. Copyright basically copyright protects content. Okay. It's the law that protects different kinds of content. So literary content, artistic content, musical content, even broadcast, audio recording. Those are the things that are protected by copyright.
Okay.
So when you think of a particular, I'll give an example, this bottle. Let's say the advertisement that was used to promote this bottle, the song, the jingle in it, that's the content of the advertisement to be protected by copyright. Then the design of the bottle is going to be protected by a different law, which is called industrial design.
Okay.
Now, if there was a name on the bottle, a printed logo belonging to the manufacturers, that logo will be protected by trademark. So trademark protects brand identity, industrial design protects product design, copyright protects content. Then we will talk about patents. Patent protects innovation. So when I say innovation, mostly scientific and technological kinds of innovation. So I think that's when, as a creative, you're going to be asking yourself, what kind of content am I creating, or what kind of product am I creating? Is it something that will require a unique packaging? Is it something that will require a unique brand identity, or is it just simply the content itself that I'm trying to protect? By the time you identify what it is you're trying to protect, then you can now go forward and say, okay, these are the laws that protect it. This is what I'm going to register. This is what I don't need to register.
Okay, so as a creative now, do you have laws that protect a design from from being copied in when you do not want? Because I know some designers who have, so I don't know what law, because if you are saying patent now, it's mostly technological, and trademark is about the brand, right? It's about the branding and everything. So what now protects your design in a case where you do not want another brand to be taking your design?
So designer will be under industrial design, which protects all kinds of product design, whether edible designs, that's designs for edible products, or even designs like clothing. So for instance, if it's in a fashion scenario, the unique design that you have will be protected by industrial design. It's all part of what we call industrial property. So industrial designs are what will protect something like that from being mass produced. And if you can actually go to court, but the only thing with it is that you have to register it. Unlike copyright is already has automatic protection from the moment you put it in a fixed form and you publish it. But industrial design requires registration. Of course, you can go to court and argue that you've used this design, you have distributed it before the other person's registration, but that will be up to the court to be able to judge and see if your evidence holds weight. But ideally, how you can prove ownership is to go and register it.
Okay. Talking about evidence now, say for instance, creative right now has the whole industrial protection of a design, right? Are you supposed to make it public? Because I'm just taking, for instance, somebody sees this and decides to copy it, right? Meanwhile, you haven't made it public that, okay, I have this protection over this, so therefore you shouldn't copy. Can you be able to take someone to court or hold someone when there's a copy on that?
What I would say is that if you have an intellectual property, the first thing that should go through your mind is to register it, to protect it first before distribution. Because even if you are able to tag this particular person and say, hey, you stole my work, the chances of you getting all those things back, the chances of you proving that you are the original owner, not just to the court, but to the general public, to your market, may be quite low. So for instance, if you've already published it and like 4 or 5 designers are already printing it and distributing it, first of all, you may not be able to track all of them to even be able to sue them in the first place. Secondly, even by the time you do that, there's already confusion in the minds of your customers. And number 3, by the time, even when you go to court, the amount of money that you may get as damages may not be able to sufficiently compensate you for what you've already lost, especially in potential revenue, not just the revenue that you've lost.
Okay. Yeah. So now, where the buzz is, let's talk about performance.
All right.
Right now, this is the artist and the rest. And there's this thing that's been going around. Oh, people are talking about royalties. This one has lost his royalties. There's a news of somebody like Asake and Olamide. Olamide has told him to hold all his royalties and all of that. Just explain to us what these royalties are. How do they get them? How do artists, first of all, actually make their money? Let's even start from there, if you can. How do they even make their monies?
Okay, well, royalties, first of all. Royalties are simply the amount of money you pay for copyrighted works.
Okay.
So basically, the royalties of a book will simply be at the amount of money that you got from selling the book. Same with music. So now, in the olden days, I can't give a specific time period, but earlier, before this modern world, what we had as royalties were usually something where people made music and they printed it on sheets. So that's why you see them using a lot of those musical signs to show the melody and all those things. And when they printed it, they would sell it. So that was their way of selling the music, especially before the technology of audio recordings were everywhere and easy to buy. That's why you see some old movies that someone will be able to recreate a Mozart music, it's because they have the music sheets with them. So those papers that they were selling are something we call publishing, because they will publish it and then sell it. So publishing is basically a type of royalty, or should I say the amount of money that you are entitled to for the composition of your music. This is not the audio recording. So this is like, there are two kinds of composition. There's the melody or the beats or the instrumentals, and then there's the writing, that's the lyrics of the song. So if you are a songwriter, you are entitled to publishing. If you are a beat maker or an instrumentalist, you are also entitled to publishing. Now for the performers, the moment you go to a studio and record it, you're going to create an audio recording, what the law recognizes as sound recording. So when you go to register at the Copyright Commission, they'll ask you, if it's music, is it a musical work or is it a sound recording? So if it's a musical work, that means it's lyrics or beats or the instrumentals. But if it's a sound recording, that's the masters. That's what people refer to as masters. That's the final version, that's the final audio version of your song. So basically, musicians should understand that, okay, am I the songwriter? Am I the beat maker? Or am I just the person that performed the song? If you perform the song, you're only entitled to the masters, which is what we also call mechanical royalties. But if you wrote the lyrics or you wrote the beats, then you are entitled to publishing. So most times what happens is, especially when we see scandals online, is that people don't know which is which in the first place. And where they get it from, we have something called performance rights organizations. So performance rights organizations, ironically, actually give out pay up royalties for publishing, not mechanical royalties, publishing. So performance rights organizations, good examples would be BMI. They are I think they are localized in America. We also have ASCAP. In Nigeria, the particular collecting society that collects these kinds of royalties, they actually collect all types of royalties. But that one I just mentioned in America, they only collect publishing. Then we also have mechanical rights societies or mechanical rights organizations, MROs or MRS. They collect only the royalties that accrue from the sound recording. So what happens is, but in Nigeria, what we have is, a good example is MCSN, that's the Musical Copyright Society of Nigeria. What they collect is they collect all kinds of royalties. So if you're registered with them, have in mind that they will collect every kind of royalties that accrue to you. So another thing I would say is that we, even under mechanical royalties, which is your audio recordings, we have interactive mechanical royalties and non-interactive. So interactive is what you have on streaming sites. When you listen to music, the money that is being paid to the musician by maybe Spotify and the rest, or if they go through an aggregator like DistroKid, the money that they get is interactive mechanical royalties. But if they go through an organization like Sound Exchange, what they're going to get is non-interactive, and that's what you get from that's royalties that you get from places like radio stations, especially online radios, that you do not determine which song you are listening to. Okay. And ideally, even when your music is played in a mall, you're supposed to get non-interactive mechanical royalties.
Does that ever happen?
Yes. Well, technically, it's the job of these collecting societies like MCSN. It's primarily their job to follow through and make sure that everywhere this music is being played, they are dropping money. Okay,
so after the break, you're going to tell us how to follow this money as performers, because that's what we're interested in, knowing how to follow the money. All right, we'll be right back in conversation with Tem right after the break. Do stay tuned.
In this 21st century, where all the information we need is now in the palm of our hands. News from around the world, entertainment, celebrity gossip, sports, and much more. The only thing that you need is the right source. Viewer TV is now on the go. Simply check us out on our social media pages on Facebook, Instagram, YouTube, and Twitter for all the information you need.
Many thanks for staying with us on Viewer Exclusive. I'm still in conversation with Tem Larry, an IP and entertainment lawyer, and she's giving us, we're schooling right now. we're going through a process of schooling. Like, so you've broken down to us what royalties mean and all of that. So explain to us right now in details how, as an artist, you can protect yourself, you can follow these monies and make sure, especially when it comes to the kind of deals, what should we be looking out for and the kind of deals that you're signing with your labels and all of that. And also another question, so that I don't miss this, is it possible for an artist to be able to follow royalties or stuff like that personally when you are under a label?
Okay, what I will say is it depends. You have to check your contract if you're actually under a label or if someone is just helping you. It's very important.
Okay, so that's different.
Yes, because a lot of times some contracts are just, hey, we'll give you this amount of money and then you give us this amount of money in return. It's not really a label. A label is supposed to offer more services than just money. So they're supposed to do everything from helping you create to helping you protect, to helping you promote, to help to tracking your money. So that's what a label is supposed to do. But if someone is just dropping money for you to spit out money by the time you're done with your music, then that person is an investor.
Okay.
Or the person could just be a philanthropist. Then there's another thing again. Is the person a manager? Are you the one hiring the person or is the person hiring you? So basically, under a label situation, they are not necessarily your employers, but the relationship is very similar to an employment agreement because there's a bit of exclusivity with it. Then if it's a manager, then you are the one employing that person and not the other way around.
Yes.
So if you're the one employing a manager, then you're not supposed to expect money from that person in the first place. But if you are under a label, then of course you're expecting much more investments than just money. So then in terms of following your money, I would say that the first thing you need is a lawyer, because all the details I may mention here, I'm just going to mention just the shallow parts because they can be quite overwhelming.
Sorry, before you go there, even when you're under a label, it's important for you to have a lawyer.
Yes, okay. Very important. So regardless of the relationship you have, whether it's a label, it's a manager or an investor, it's very important for you to have a personal entertainment lawyer, not just a general lawyer, because law is a very wide field and there are different lawyers for different kinds of things. And I'm sure a good example would be like the election petitions. There are people that specialize in those specific areas. So what you need first is an entertainment lawyer that will actually explain everything to you. So for instance, you're entering into a contract to someone that wants to help you blow. That's usually the terminology they use. So what you're asking, is this person your investor? Is this person your manager? Is this person going to use their connections to get you business and you give them a percentage of your stuff? Or is this person also going to involve and invest money into you? By the time you've determined what kind of relationship you have, the next thing is the percentages. Percentages of what? Is it a 360 deal where no matter the amount of money and no matter the source of money, this person is entitled to a cut? Or is it a part for particular kinds of royalties? So your contract can say something like this person is entitled to 30% of all your publishing. But if you are not the songwriter, if you don't write any of your songs, if you don't make any of your beats, then you actually technically don't even have publishing in the first place to give somebody a part of. Or if the contract is 30% of all your royalties, then you know that yes, it's publishing plus mechanical royalties. And so basically the thing is you need to understand the kind of relationship you're having and you need to spell it out before you start working with that person. And one way to protect your music or anything is to make sure that you have a timestamp on it. So when I say timestamp, for instance, if you record in a studio, upload your music to maybe like a platform or maybe a cloud space, storage space where it will have a specific date that it was created. The reason is because copyright protection is automatic from the date of full creation. That's when it's created in a transferable format, whether an audio recording or written in a notebook if it's just lyrics. So what happens is that the first way to protect your work is to ensure that you've put it somewhere that has a timestamp, somewhere that I can say this is when it was created. So that timestamp is what we usually refer to as metadata.
Okay.
Now, the next step is to go and register. But the thing with registration is that a lot of artists, especially upcoming artists, they may be able to squeeze money together to be able to record in a studio. They may call in some favors, but they may not have enough money to register it at the Nigerian Copyright Commission. That's going to a lawyer and paying, because you don't just, when you go to a lawyer, you don't just pay them the amount of money for the registration, you also pay them for their professional fees.
Okay.
So some of them may not have that amount of money. That's why it's very important for you to do that timestamp thing first. And then in every conversation that you're having with anybody, make sure that the conversations are recorded somewhere. It doesn't have to, I'm not saying be sneaky and do an audio recording, but make sure that after every conversation, follow it up with a message saying, okay, this is what we agreed, and thank you, sir. You don't have to even be haughty or rude about it. You'll be like, thank you for saying this. I really appreciate this, especially when the relationship is still rosy.
So you have something as an evidence.
Exactly, to say that, okay, these are the oral things that these are the things that we agreed on orally. Then the next step will now be the contract. So you have to identify from the beginning of the contract things like, who are the parties? Are you signing with a company? Are you signing with an individual? If you're signing with a company, is there an employment agreement? And the reason why this is very tricky and why you need a lawyer is because a contract can be titled employment agreement, can be titled management contract, but the content will be a label and investment contract, or it could even be an employment agreement which has different rules that govern it and different construction, the words and everything. So it's very important for you to understand the kind of contract you are dealing. But the truth is, there's almost no amount of teaching I can explain, or teaching I can teach, or explanations I can give that will give you the understanding of every nitty-gritty thing inside. So it's best to get an entertainment lawyer, someone that understands the industry, because they can now say, okay, this particular clause that is titled compensation is actually you that is paying, they're not the ones paying you. So it's very important to do that.
You talked about a creative, an act, like a copyright act. So explain to us now briefly what the creative rights are. Let's know what's attainable within the confines of the law for artists, so that we know that, okay, this is my legal right to do this. This is in general, after everything that you have said.
Okay, it's quite a list, but so that we don't spend too much time, I'll talk about the most important one.
Okay.
The most important one is monopoly of use and license, which means the artist or the creative is the only one that has the right to be able to use the work and license it to someone else to use the work. So this monopoly of use and license has a time span, a lifespan. So if, for instance, you as a creative, you as an author, the law calls you an author, it doesn't call you a creative. So you as an author, if you are the owner, if you, for instance, when you created that particular work, you did not sign an employment agreement saying that you are a staff of somebody, or it's not a company that creates it. Once you're in that kind of scenario where you're completely independent and you own your intellectual property, you will own it for your whole lifetime plus 70 years after you're dead. If it belongs to a company, it may not be as long. Other kinds of work, maybe like a broadcast, sound recording, that's the masters, it only lasts for 50 years from the day of publishing. That's from the moment you distribute it, it's only 50 years that it has. So for instance, let's say you write a song at the age of 15 and you record it. The lyrics and the publishing part of the song, that's the composition part of the song, will last for your whole lifetime plus 70 years. But the audio recording will only have protection for 50 years, meaning that it will lose protection when you are 65 years old.
Okay.
So by the time you understand this lifespan, you can't just be signing contracts anyhow saying that, oh, you get out of it.
Yeah.
It's very important to look at. So I think the most important rights that you should think of is how long you actually own this thing, how long you have monopoly. Now, after that 50-year mark or the 70-year mark after a person is dead, it goes into what we call the public domain. This means that you can still use it, but you're not the only one that has a right to it. I'll give a good example. This cartoon, Winnie the Pooh, went into the public domain, meaning that anybody can use the story for anything. But here's the tricky part. Something like Winnie the Pooh, the design of the character is protected by trademark. But like, because it has been registered as a trademark and is usually used for merchandise and other things, that one is different. So that the character design is not in the public domain. However, the story of Winnie the Pooh itself has entered the public domain, so anybody can use it.
All right, Tenari, this is a lot. Before we let you go, because we're running out of time, this feels like we can take all the you're trying to explain this to us. Where do you have any platforms or anything where we can actually come and get more information and learn these things?
Yes, I do. I have a platform called Larry's Cafe. It's a website, larryscafe.org. That's LARISCAFE.org. And I actually am working on 2 courses at the moment. So one course is for professionals, people that work with creatives, not necessarily the creatives themselves. And then there's another course to educate the creatives themselves. So the creatives course, I title it creative rights. So it's every kind of right, like the list I mentioned that I couldn't highlight. So we go through every single right of every kind of creatives, even down to architects, not just those in the entertainment industry. So I have that course that explains everything. And then there's another course for professionals. It's called intellectual property valuation. So that will explain how to value an intellectual property, especially when you get to the negotiation, when you get to negotiating tables to say, okay, this is how much you want to sell.
And we can find all of that on your website.
Yes,
that website will be available for our viewers so that we can get in depth and especially protect ourselves. It's such an amazing job that you are doing to see that creatives are being protected. Fortunately, we have come to the end of viewer exclusive for this episode. I've been in conversation with Janet Temlari, an IP and entertainment lawyer. Thank you so much for coming on. Until I come your way again on viewer exclusive, my name is Chinon. So check us to have a good time.
Thank you.